Joining me now is Jeff Gaddy. He is an attorney with Levin Papantonio. And Jeff, I think we spoke last time. Last time I was here. Oh, here. I'm sorry. Let me get you. All right. Why don't you just try that one there?
Yeah, we did. We spoke about a year ago about the opioid stuff.
Okay. Sorry. Give me one more second. Okay. Give me that now. All right. So Jeff, I think we spoke a year ago about
We did.
Okay. And so, give me a sense. You're working on the opioids. Just refresh everyone's memory as to what you're working on. What part of there's various litigations going on across the country.
Sure.
There's just a settlement in Ohio. I mean, tell us about what's going on.
Sure. So we represent several hundred local governments in litigation against the manufacturers and distributors of opioids. It's to kind of boil it down to its simplest terms. It's a supply and demand type of case. We allege that the manufacturers of opioids misled the doctor and patient community and drove up the demand for opioids by falsely telling folks that they were not addictive and that they were safe, and the distributors they were right there with the supply, in spite of duties that they had to be on the lookout for and report suspicious orders of opioids. They continued to just flood the market with these pills that has led to so much addiction and other consequences, death that we've seen with these. So that's the basis of the litigation.
So are there two sets of defendants here? The manufacturers, who include what? Purdue and...
Sure. So that's the Purdue, Johnson & Johnson, Endo, Mallinckrodt, a lot of these big branded and also generic manufacturers. And then on the other hand, you have the distributors.
And there's three major ones, right?
So there's three major ones that most folks, I'd never heard of them until I got into this litigation, but then you look into them and they're Fortune 15 companies.
Wow.
So they are very well funded. McKesson, Cardinal Health, AmerisourceBergen. And so they're the kind of traditional distributors. And then you have a lot of folks who you and I would probably just think of as pharmacies. Walgreens, CVS, Walmart. Well, what these companies did was 15, 20 years ago, they realized that hey, instead of paying the premium for having one of these big three distribute us our drugs, we can go out, get our own DEA license, and just distribute to ourselves. So those folks have attempted to brand themselves as simply pharmacies, but they also have a distributor license, which obviously subjects them to the same duties and rules and regulations as the others.
And that's the key there, because once they assume the responsibility of a distributor, there are statutory obligations that they have that are specific to the distributors, right? Just explain that, because and at one point, one of the stories was, I don't know if this was about 4 or 5 years ago, they were lobbying hard to get those statutory obligations eased, because I think they knew they were headed for a problem here.
You're absolutely right. So the Controlled Substance Act has been on the books since 1970, and it's been there for decades, where they have this duty to be on the lookout for and report anything that doesn't pass the smell test when it comes to orders of pills. Can be size, quantity.
Okay, so they're using data, and they have the functional equivalent, I guess, of actuarial tables for what they anticipate the usage of drugs are going to be in any specific region or wherever it is, distribution center they have.
What we've learned is these folks have data about data. I mean, they have visibility from the top to the bottom, and what they're charged with under these rules and regulations is utilizing that data to make sure that they're not supplying pill mills, to make sure that only legitimate prescriptions are being filled, and the allegations in the case are that these folks have completely missed the ball when it comes to their duties and rules and regulations.
Okay, and so that's basically, and so who are your plaintiffs? I mean, who are your plaintiffs in this instance?
So local governments, cities, counties, towns, boroughs, any local government, and a big of one of the big calls to arms here was, kind of harkens back to the tobacco litigation, and there was a $247 billion settlement in tobacco. It was completely driven by the attorney generals, and a lot of that money went to fix potholes and build highways. And what we saw in this case was that the damages were really felt on a local level. It was the cities and towns who were dealing with their citizens who were becoming addicted, who were trying to fund treatment centers, and they just weren't able to do so. So represent hundreds of local governments who are fighting to get funding so that they can address the opioid impact locally and try to make a difference in their individual communities.
And this is, and the impact ranges from dealing with future addicts, or you know that.
Sure, it's all of the above. We talk about trying to gather funds to abate this public nuisance, this epidemic, and we talk about it very, very globally. Obviously, every location is different. We would never tell anybody how to spend any funds they recover for this, but education is a big thing. I mean, we've seen that with the tobacco, where the ads are finally starting to roll out from the tobacco litigation. So we think that's important, that you should be in the elementary schools teaching kids that the pills in their parents' medicine cabinet are just as dangerous as a needle, and if a heroin needle goes into their arm one time, it won't be the last. We think law enforcement and jailing. I mean, those infrastructures are so stressed by this crisis. So we don't think this is a problem you can arrest your way out of by any stretch of the imagination, but law enforcement, we've had a couple of instances where we've had law enforcement officers overdose on the side of the road searching vehicles because the fentanyl can be absorbed through the skin. And you have officers who are searching a car on the side of the road, touch fentanyl, absorbs through their skin, and they overdose on the side of the road.
Oh my God!
So thankfully, those officers have been revived, and we haven't lost one. But that should never happen. That should never happen. So making sure that all law enforcement officers have the resources to kind of appropriately deal with this issue. And then, of course, the biggest bucket would be addiction treatment services. So that it's needed. I have yet to be to a community, and I've been to hundreds of them now, working on this case, and I've yet to be to visit a community that tells us we have empty beds, we have space available. Nobody does.
Right.
They're all maxed out. They all have waiting lists. They have people on waiting lists who overdose and die, and that's something that shouldn't happen. And that's what we're trying to fix with this litigation.
Okay, so what is the status now? How is this related to what's happened in Ohio? Was that just two specific districts? Like, because they're it feels like every other day we hear a different report of a different settlement.
Sure.
Maybe one just with Johnson & Johnson, maybe one that is just for specific counties.
So what you're saying is an example of the lesson that trial pressure brings about resolution. And as a trial lawyer and as a firm that tries a lot of cases, that's something that we know better than anybody. So what we're seeing here is we had a trial that was supposed to start Monday. I was supposed to be in Cleveland, not here, but Monday morning the case settled. There was several defendants that entered into a settlement, several others that were severed out and will probably go to trial in the next couple of months. But that's what we're seeing is all the local government cases, the ones filed in federal court, consolidated up in Cleveland, Ohio, in front of Judge Polster, and this was the first trial that we'd been building up to for the last 2 years, and as I said, trial.
So how many plaintiffs?
Resolution.
How many cities or municipalities, whatever it is, I mean, they towns? I mean, how many of those are participating in this settlement?
There's about in the settlement, it's just the two trial counties. So Judge Polster determined that Cuyahoga and Summit counties, which is where Cleveland and Akron sit, were going to be the two counties to go to trial first. So as that trial date was set, we saw the dominoes start to fall. You had INSIS file for bankruptcy. You had Purdue file for bankruptcy. As we started getting closer and closer to trial, Johnson & Johnson settled with the two counties. Mallinckrodt, another big manufacturer, settled with the two counties. And then literally at the 11th hour, we had the big three distributors, McKesson, AmerisourceBergen, and Cardinal Health, settle with the two counties. So
these two counties were suing, like, it sounds like a half a dozen players more.
I think the list was about 20 to 23.
Oh, okay. And so, and they're bringing this case against all those plaintiffs contemporaneously, or
against all those defendants? Yes.
Excuse me, those defendants contemporaneously.
Yes.
So how do the defendants organize themselves, or were you going to have, if you went to trial on behalf of those two counties, and there's 20 defendants.
Mm-hmm.
Do they have like 20 different legal teams that are arguing this?
They do, and look, Judge Polster is a fantastic judge and has done a great job managing this case. And one of the things he did about 4 months ago was say we don't have room in the courtroom for 23 defense attorneys. So we essentially split the case in half, severed out approximately 8 to 10 of them. Said that'll be a second trial. And so then we moved forward with about half the number that we started with, and we saw the results of that. Once they knew that there was focus and attention on them, the settlement started to roll in.
And can you tell us what the numbers are on that settlement?
Sure, they've been publicly reported. So Mallinckrodt, which is a big manufacturer, branded and generic, paid about $20 million. The big three that settled on Monday paid a total of about $210 million is what's been reported there. Teva is a big manufacturer based in Israel, but they have some entities here in the U.S. It's been reported they paid about $5 million on Monday. So yeah, fairly substantial numbers.
So you're talking almost about $250 million between these two counties.
Sure.
And so, and presumably, they have a split in between, between them, and then this money goes into those various services that they need. Now, how these counties end up spending that money is up to them.
Absolutely.
Right, okay.
And Cuyahoga County's already announced that they've formed a specific task force to focus on exactly what the needs are in their community, which is what we've been preaching for the last 3 years.
Okay, so now, what does these settlements, do they basically establish benchmarks and an algorithm for the way that other counties, municipalities will ultimately, presumably, settle?
Sure. I mean, that's the whole purpose behind setting some of these early, what they call bellwether trials, to kind of test the waters and see what how a defendant values a case when it comes to settlement, or how a jury values a case. And obviously, I mean we talked about the numbers. They've been reported. They're significant. So the fact that these folks were ready to put that type of money on the table shows what they were concerned about as far as a jury verdict.
So how will that, and then presumably when these, we move down the line with these other counties and municipalities, it's some type of formula like Cuyahoga County had X number of people and had reported X number of ODs and has a budget of Y, and these many pills ended up in this county over the course of 15 years, and relative to the 125 million they're going to get, that's what sets the formula.
Sure. So there's a bunch of different data points you could look at as far as metrics for determining something like that. What we've kind of focused on is amount of pills, which you referenced, and we're actually looking at it in MMEs as opposed to just pills. So morphine.
MMEs?
Yeah, morphine milligram equivalents.
Okay.
So that's kind of how, you have a hydrocodone pill and an oxycodone pill. They're both just one pill, but the oxycodone pill is 50% stronger.
Right.
So that's what we're looking at is potency. So we're looking at MMEs going into communities. We're looking at overdose deaths. We're looking at diagnoses of opioid use disorder. So how many folks are addicted in the community, and those are the three data points that we've kind of focused in on the most.
And so presumably we're going to start hearing about settlements cascading over the next 6 months?
It's going to be interesting to see how it plays out. As I've said a couple times, trial pressure brings about resolution. In Cleveland, there's no more trial dates right now, so we expect there will be one roll out soon. If you remember, I told you about half of the defendants were severed out, so we do expect there to be a trial date for those folks that'll roll out soon, and we'll work those cases up aggressively. We'll prepare them for trial, and if the defendants make an offer that our client tells us to accept, then we'll accept it. But otherwise, we'll go and try the case, which is what we were prepared to do starting this week.
Now, are there other sets of plaintiffs out there that are pursuing other litigations? Are attorney generals involved in this anymore? Or
Sure. So I think Nebraska is the only holdout. I think otherwise every attorney general has either brought a case or announced the intention of bringing a case, and retained counsel. You have cases that have been filed.
why
by hospital.
Nebraska? Is McKesson located in Nebraska?
No,
or
they're
what
a
is-
San Francisco-based company, and out in California. I don't know. I don't know what's going on in Nebraska, but for whatever reason, they've decided to stand on the sidelines so far. So yeah, you have hospitals that have filed cases trying to seek reimbursement for indigent patients that they've treated who've come in with overdoses and things like that. You have third-party payers who are filing lawsuits claiming that they were the benefits and risk of opioids were misrepresented to them. So it's complex. There's a lot out there. The local government cases and the attorney generals seem to be kind of leading the charge, but.
And what happens when the Purdue, for instance, says we're bankrupt? Are they bankrupt? Are they protecting themselves? Like, where does a settlement, or where would a court order, essentially, where would that sit relative to the other creditors that they're getting bankruptcy protection from?
So it'll be interesting to see how that plays out. So they filed a Chapter 11 bankruptcy. They've been very public about their willingness to reorganize, to spin the company off, to rename it, to use the bulk of any funds that they have available.
Is there any type of like recourse in that situation? I mean, it seems like the idea that you could sue this company for doing what they did in marketing this and manufacturing it and having an obvious awareness that this seems like a really successful product, and it shouldn't have been this big.
Right.
And earning $1 billion more.
Well, let's be clear. It wasn't an accident.
Right.
It was as big as it was because of the actions that they took.
Of course,
It was
of course.
everything was strategic.
And-
Everything was intended.
And then they just say, well, we're going out of business. All the C-suite, the Sacklers, they walked away with all the cash. The business is just a sort of, presumably just sort of like some type of shell, right, essentially. And they're going to restructure. They're just going to be they're going to change their name and move out of town.
So it's going to be interesting to see how it plays out. There was recently a temporary stay entered, meaning kind of a pause on all the litigation against both Purdue, their affiliated entities, and also the Sackler family. And the court gave everybody until the first week of November to kind of decide what type of discovery would be permitted onto the financial status of both the company and the Sackler family. So those negotiations are happening now, and obviously that's a huge question. How much money did because it's a private company. They don't have
Right.
these
There's no
public
shareholders, right.
they don't have these public filings. They don't have the E3s.
Can you go to the bankruptcy court and say you can't allow them bankruptcy protection, or
So there's a lot of different vehicles available. I think that if these negotiations come out favorable to us and we're able to get the transparency that we think we're entitled to, then we might be satisfied with that. And that's what we want to know. We want all the cards on the table, and we want to be able to see the full picture before we enter into negotiations. So that's what's happening now when it comes to that company.
Why would they agree to do that?
Well, I think they know that the judge is fully aware of the entire situation. He hasn't been living in a
Right.
box for the last decade. So he knows the history. It's very public. He knows about the crisis. And so they
So it's really,
know
they're
that.
just ultimately they're satisfying the judge, and for the judge to be satisfied, both parties need to come and say, like, we've made an agreement. And if they don't satisfy the judge can get more onerous about what.
The judge was very clear that the stay he put on any litigation against them was temporary.
Okay.
And that was that he harped on that several times that it's a temporary stay, and I think that if the Purdue and the Sacklers had their listening ears on, they heard that, and they knew that they need to come to a fair outcome by the first week in November, and allow everybody to see
just how much money they've walked away.
Exactly.
Profiting off of the abject misery and suffering they've caused. Hundreds of thousands of people across the country?
I have no quibbling with that number at all.
Yeah. Wow. Is there anything that is there anything else that we should know about it, or?
So, we were all geared up. We were ready to roll with trial this week, and then when the settlements happened, we're kind of press pause for about a day, and now we're already hitting the ground running when it comes to the second trial case. We kind of have what we're calling track B up in Cleveland.
You're from Florida.
Absolutely.
And you thought that you were going to be in Ohio for the next 3 to 6 months.
Yes.
And now you're in Florida.
Fortunately, Judge Polster was pretty good about putting reasonable limitations. So I was going to be home by Christmas, but yeah, absolutely. So we were expected to be up in Cleveland this week and for the next several weeks, right, as we put on this case against these folks. So
Jeff Gaddy, Levin Papantonio, thank you so much for stopping by.
Thanks,
really
Sam.
Interesting stuff. Appreciate it.
Thank you.